big deal. You might also have a lease where you sign, a rent agreement where you can use it for a set amount of time. Or another way is an easement. And an easement is a real property right. It's less than full ownership, but it's usually more than something like a lease. So there are many different types of easements. There are express easements. Express easements are simply easements where you have an agreement with the landowner. Usually it's written. In fact, most of the time it must be written because it relates to real property, and it is recorded on the real property deed through the recorder's office. There are also things like utility easements. Those are usually created by Utah code. And in fact, if you own property in Utah, you almost certainly have a utility easement across your property. Otherwise, you wouldn't have things like water, sewer, power, and gas. And that just gives utility companies the ability to put utilities on your property and to access your property for purposes of maintaining the utilities. There's also something called a prescriptive easement. We'll go into that a little bit later, but prescriptive easements usually arise, or they always arise, from use of the property. And then finally, there's something called a conservation easement. Those are relatively new under the law. And when I say relatively new, what I mean is in the last 25 to 30 years. And those are governed in part by federal statutes and in part by state statutes. And they are far more involved than a general purpose easement generally would be. Like I said, easements are a type of real property right, usually more than a lease, but less than title ownership, or what we would call fee ownership. And all easements require a dominant estate. The dominant estate is the estate that holds and benefits from the easement, and then a servient estate. So a servient estate is the estate that is burdened by the easement. You can see in this graphic here, the dominant estate is in red, and that looks like a piece of property that's accessed from a public road via a driveway or a roadway that crosses property A. And so in order for the dominant estate owner to access his or her property, they need an easement across property A, which is the servient estate, in order to access that property. And so basically what they have is a right to use that that roadway to access their property, and that is the easement. So if you could advance the next slide, Carly. Okay, so express easements. Express easements are real property rights, but otherwise operate much like a contract. So usually for an express easement, you have an agreement with a landowner that allows you to access the land for a specific purpose. So it might be, like I said here before, a driveway, or it could be for a trail. It could be for anything really. And the scope of the easement is really up to the two property owners, the person that owns the dominant estate and the person who wants to access that either through a servient estate or another way to think of it is the land that's on the other, either through a dominant estate or a servient estate. And the servient estate just might be the surrounding land. It might not be one estate, it could be multiple estates. Now, express easements usually happen when two property owners agree on how the easement should work, quote, on the ground. But they could arise otherwise. So maybe you go to court and you file a quiet title action, and the court finds that there's a specific use or a specific easement that existed on that property and records that against the deed. Well, that could be viewed as an express easement because it's then recorded against the deed. Another way that an express easement might come to pass is that you purchase a piece of property that already has an easement attached to it. So that would be called an easement appurtenant because it's running with the land. So say the person that you purchase your property from gave an appurtenant easement to an adjacent landowner in perpetuity for that landowner to use a driveway across your land. And when you acquire that piece of property, you also acquire that easement. Well, you generally, in that situation, probably wouldn't be able to destroy that easement because it's attached to the land. And so you'd have to continue to allow your neighbor to use that easement to access their property. There's also something called an easement in gross, where you could just give it to a specific person. And maybe when that person died or after a certain amount of time, that easement expired, and thus it wouldn't be granted in perpetuity and wouldn't run with the land. For the most part, easements can be set to expire at a specific time and can be modified. Express easements, I should say, can be modified through later agreements. So next slide, please. Okay, now I'd like to go over prescriptive easements. Let me say prescriptive easements can be very complicated. If you look through Utah case law, you'll find cases in almost every year. There are hundreds of cases, maybe at least dozens of cases that deal with prescriptive easements. The reason those are so frequently the subject of litigation is because they arise from use of the land, and they are not subject to agreement. It's because one landowner wants to use the property of another, and that other landowner doesn't want that person to use their property. And so what happens is the dominant estate owner or the hopeful dominant estate owner goes to court and tries to establish use of that easement through a court case in hopes that if the court sides with the dominant estate owner, the court will record that servient easement against the servient estate, and the dominant estate owner can continue to use the easement. So to establish a prescriptive easement, the dominant estate owner must establish, actually it's 4 elements by clear and convincing evidence. 1, the use was open and notorious, means you weren't sneaking around in the dead of night and using the property. You were using it and you didn't care who saw it. Anybody could see you using it. The use was continuous, meaning that doesn't mean you have to use it every day, but you're using it for the purposes for which you needed it over a certain set of time, actually 20 years, that's one of the elements. And then the use was adverse, which means you didn't get permission from the servient estate owner. So basically you're just using it and you didn't ask permission and they never gave you permission. And then again, you have to use it for 20 years. Now note here that in order to establish that with the court, you have to establish those elements by clear and convincing evidence. So when you go to court, there are various evidentiary levels. The highest level is reasonable doubt. That's what applies in a criminal case. It's a really high evidentiary level. The second highest is clear and convincing evidence. That's higher than you would need to prove if you went to court to prove like a negligence claim or almost any other civil claim. So if you go to court to prove a prescriptive easement, you actually face a pretty heavy evidentiary battle to get that prescriptive easement proved up. You also have to do it through a court case. Otherwise, it would just be an express easement because it would be an agreement between the landowners. And because of all these various things, prescriptive easements are not a great way to establish a right to use the land of another. They're limited also by the historic scope of how the easement was used. So you can't use a prescriptive easement to access the property for purposes of, riding your horse across somebody's land to access your cabin, and then go to court and hope to say, well, I've used my horse to access that land. Now I want to build a 4-lane highway. That's not how prescriptive easements work. If you could go to the next slide, please. So yeah, there we go. Okay, next type of easement that I wanted to talk about is conservation easements. Conservation easements are a type of express easement. They're agreements between a landowner and the holder of a conservation easement. But the purpose of a conservation easement, unlike other easements, is not necessarily for access to land, but instead it's to preserve the land for specific purposes. For example, conservation purposes, whether that be conservation of wildlife or conservation of ecological habitat, or perhaps conservation of recreational activities, or all of the above. These particular easements are governed by specific federal and state laws. One of the benefits of that is that if you do enter into a conservation easement, you can enjoy certain federal income tax and state income tax benefits, but you have to do it the right way to enjoy those benefits. They are usually established through thorough written agreements. You don't have to go to the next slide right now, but in a minute, I'll share a QR code that will link you to the conservation easement that was recently recorded for Vital Bell Falls. And you'll see, if you wanted to review that it's about 130 pages long. And it includes scientific studies, very specific language as to how the landowner can use the land versus what needs to be, what type of conservation needs to take place under the terms of the conservation easement. And you have to be sure to include specific provisions if you're the landowner to make sure you can continue to use the land in a way that that you believe you want to use the land, or that you've historically used the land for in the past. So you can go to the next slide now, Carly. Like I said, here's that QR code. You can go and look at Bridal Veil Falls Conservation Easement. That easement is held by Utah Open Lands. Utah Open Lands is a third party that actually holds many conservation easements, and they specialize in creation of and holding those conservation easements. So like I said, usually these types of conservation easements are held by a third party that specializes in creating and holding the easements. They're almost always granted perpetually in perpetuity, which means once they're attached to the land, they probably won't get changed unless you want to go through a thorough process to revise the easement. They have to meet strict requirements under the law. You're probably going to have to consult with attorneys, biologists, ecologists, accountants, and then careful coordination between the easement holder and the landowner in order to create them, because they are rather complicated. As a result, they take time to set up, and because they run with the land, they can't be undone as easily as another easement might be, or simply rewritten. But they do constitute a very powerful tool for conservation, and they can result in significant benefits for the landowner. So next slide, please. Just very quickly, a few other types of easements. Utility easements, I already talked about those, usually a creature of statute. Easements by implication and necessity, these are common law easements. They're kind of like prescriptive easements. Easements by implication arise because of a way the property was used prior to it being transferred to somebody else, and easements by necessity are usually arise because you have to have the easement or you can't use your property. That generally arises when you might have a landlocked parcel and you have to access it in some way. I'm not going to go into those here, but those do exist under the law. And then finally, there are other easements that are created by statutes. One for livestock trails, there's one in Utah for the operation of military bases. There's even one for solar energy that basically says if you have a solar energy facility and you have an easement for that, somebody can't come in and block the sun to your solar energy property. But again, these are all easements created as a matter of law under the code, and so you have to follow the code to create and take advantage of those easements. Next slide, please. Okay, so that kind of wraps up the easements, and I know that I'm getting close on time, so I'm just going to quickly go through the second part of what I wanted to talk about today, and that's Utah's Limitation on Landowner Liability Act. This doesn't have anything to do with easements, but it's something that might apply to property that you own that you allow somebody else to use for recreational purposes. If you do, this act could protect you. So the purpose of this act is to limit the liability of public and private landowners towards a person that enters the owner's land as a trespasser for recreation purposes. Now, don't read too much into that trespasser provision there, because it applies if you give somebody permission to go on the land for recreation purposes as well. So it applies both to trespassers and in certain cases to non-trespassers. But it only applies in certain circumstances. So the only time it applies is if you don't charge a fee. You can't charge somebody a fee to come onto the land to use your, it has to be free. And two, it does not relieve you from liability for acting deliberately, willfully, or maliciously. So if you put a trap on your land to snare somebody and they come on your land for recreation purposes and fall into the trap and they're injured and that's what you intended, doesn't relieve you from that liability. But if you have a dangerous, let's say you have a portion of your land where the ground is uneven, there's a hole, and it's just, it's covered by some of the natural vegetation, and somebody comes onto your land and they trip and fall in the hole, that you would generally be relieved from liability for that hole, for the injury that they suffered from stepping into and being injured by that hole. That's not generally how it works. So usually when you invite somebody onto your land, you have a duty to either keep the land safe for them, or you have a duty to warn them about that dangerous condition. But this law helps to protect you in the cases of allowing somebody to come onto your land for recreational purposes. Bear in mind also, this applies to landowners. It does not relieve others who might access the land for various purposes. So for example, you allow people to come onto your land for purposes of hunting. It's one of the recreational purposes that's recognized under the Act. And as part of that, a hunting guide brings some folks onto your land. And one of the persons is injured because the hunting guide doesn't handle his firearm properly and discharges that firearm, and somebody gets shot in the leg. The hunting guide is not relieved from liability simply because he happens to be on your land, because he's not the landowner. You would be relieved from liability from getting sued for that, but the hunting guide would not. Now, let me just caveat also by saying that the Landowner Liability Act has been subject to litigation, especially in recent years. The legislature recently undertook some amendments to the legislation in order to presumably expand some of the liability protections that the Act offers, but it's still sometimes a subject of ongoing litigation. And so if you do intend to open up your land for purposes of recreation, and you're hopeful that this will allow you to escape any liability for somebody that is injured on your land, I would make sure you consult with an attorney to make sure that the purposes for which you're opening your land are actually protected under the Act. And that attorney can give you a pretty good idea of the type of liability protections that you would be afforded because of this law. So with that, I'm going to turn it back over to Carly, and thank you very much.
Thank you, Shane. That was a wealth of information. We're so lucky to have you as our legal counsel with the Utah Division of Outdoor Recreation, and appreciate all the time you took to get that presentation together. So next we've got Jim Price with the Mountainlands Association of Governments. And Jim, do you want to take over the screen share now?
Yeah, thank you, Carly. Okay, so just a quick introduction. My name is Jim Price with Mountainlands Association of Governments in Orem, and we have been working on developing trail networks in Utah County for a long time. I've been doing this since 1999, since the last century. We're going to talk a little bit about today the Murdoch Canal Trail, and actually I'll throw a little curve in there, the Lehigh Rail Trail, as examples of many of these different options for gaining access to property to build a trail. Now, what you're seeing here in pink, and I'll try to quit zooming in and out too much, but this pink line, as it runs here through 7 different cities to about this point, was the Murdoch Canal Trail. It was an open canal that carries water from the Pearl River up to Utah or Salt Lake County. That canal was enclosed with a pipe in 2011, 2012. We built and opened the trail between 2012 and 2013. So that's been open now for 10 years, the Murdoch Canal Trail. Now, if you can see where my cursor is here down in Orem, right at the southern end of the trail, from this point up here to SR 92 in Highland, where it interacts with, and let me zoom in a little bit here, it just about intersects State Route 92 or the Timpanogos Highway, if that makes more sense to you. The canal actually diverges from the trail, or the trail diverges from the canal and heads north up into Salt Lake County. So from this point back down to Orem, what is key here is that this was property that was owned by the Bureau of Reclamation. And the federal government isn't in the habit of giving or selling property rights to individuals or to groups, or to Utah County in this case. And so what they were going to do is they were going to provide Utah County with a lease agreement that would last for 25 years and be automatically renewed after 25 years. So essentially a 50-year well, not lease, but a license agreement. And that license agreement allowed the Utah County to build, operate, and maintain the Murdoch Canal Trail. Now, what's interesting about this, at least to me, is that right before we built the trail, that property was actually transferred from the Bureau of Reclamation to a private water company, to the Provo River Water Users Association. But that transfer from transfer to public ownership to private ownership required that there be maintained in perpetuity a public use of that right of way. Didn't say what that public use was going to be. This was federal regulation. So it was determined between all the parties that the public use would be the Murdoch Canal Trail through there. And so that what happened is that license from the Bureau of Reclamation turned into a license from a private canal company. And if you're on the Murdoch Canal Trail, if you've ever ridden this or walked this, you are actually on private land for that first 17 miles. Once we get up here to SR 92 and we diverge from the canal itself and head west, this was private land that was purchased by UDOT for the widening of SR 92. This was back a few years, back about 2010. And we had been planning this trail for a very long time, since about 1997, I believe, was when we first started planning on that. And we worked with UDOT to actually have them purchase ground so that we could build the trail. It's about 3,000 feet from this point to here, where we're now on state-owned property. And then west from there, we're on either state-owned property or on city-owned property until we get to, this is the Thanksgiving Point Golf Course. And if you've ever had the dealings, if you ever try to get across a golf course or you want to build a trail around a golf course, I'm not sure this is the way to do it, but this is how we did it. We worked with that golf course in order to purchase an easement in perpetuity, a public access easement, along the edges of their golf course. And right here, I think this is the, not the tee box, but the green for the 10th hole. And the trail skirts that 10th hole, comes down and ties into the Jordan River Trail down here, and we're back on the public property. That easement is also shared in this area with a private homeowner association, and we purchased an easement from them to get across their private ground from that homeowners association. And these two purchases were separated, but completely different in what we had to pay and what considerations we had to make in order to build the trail. Essentially what happened with the golf course is the golf course wanted some additional funding to help with some buildings that they were building up in Thanksgiving Point. The homeowners association wanted some additional funding to help with improvements to the HOA. This is actually a private road that we're running along that belongs to the HOA. And so we purchased these at, I believe, 80% of the normal property value. And so this is a kind of a classic, yes, you go in and you purchase an easement for public access. Where things got a little bit different and a little hairy, and where I want to kind of throw the curveball in here, is this is actually the Lehigh Rail Trail, and this runs up into Draper. This runs along UTA property, and that UTA property was given to Union Pacific Railroad, or actually Union Pacific's predecessors. And I don't remember both of those predecessors, but they were local railroads here in Utah. With the Railroad Act of 1875. And if you ever want to really get bored or really get interested in railroad acts and how railroads came about and how they own so much property across the country, the Railroad Act of 1875 is great. I've learned more about it than I ever wanted to learn. The Railroad Act of 1875 provided an easement only for the purposes of railroad business. And if that railroad business ever went away, or they abandoned that right of way, the property rights would revert to the underlying property owners. We did not know that coming into this. UTA did not know that coming into this. The state didn't know that coming into this. We learned a lot of lessons, but we thought that all we had to do was get a license from UTA to use their right of way. And they gave us that license and we began building in it. And then we began diverging from it, came out here back to where the canal, the Murdoch Canal continues north. And that license agreement with Provo River Water Users Association covered the entire canal length from Point of the Mountain back down to Provo Canyon. And so we thought, well, that's great. We'll just go up onto the existing canal. We already have a license for doing that. We found out in pre-construction due diligence, found out that the property was not owned fee title by either the BOR or by the water company. And so they therefore did not have the right to give us access for the trail on that. We had to go through and negotiate with 28 different entities to purchase easements for this piece, and it's just this piece. It's about a mile and a half of trail that we were not expecting and had no budget for, but we found the budget for, and we actually went through and negotiated all 28 of those easements so that we could get through this part of the trail. And then and I'll come back to that Railroad Act of 1875 in just a second. And then we come over here and this piece of ground, and this is, you'll look at and go, why did you go where you went with the trail? Well, the main reason is that we went where we could actually find right of way, and we could actually acquire right of way. This piece of ground is owned by the state. It's owned by the Division of Natural Resources, and they provided Utah County a license to build and operate the trail through their property. Where things got the hairiest in this entire project, and why this took so long, is we diverged back down onto the railroad right of way. And luckily, I'm gonna say luckily first. Luckily, UTA, when they acquired rights to this railroad right of way, and it actually runs up through here, they did that for the purpose of building future light rail, future tracks. And they purchased that from the federal government. And at the same time they did that, because they knew that we were planning on this trail, they asked for and were granted a public trail easement along that right of way for the very purpose of this trail. This was back in about 2010. Where things got really hairy is about 2012. The UP actually applied to abandon that right of way. And when they did, and they were allowed to abandon it, of course, because of the Act of 1875 and of subsequent Supreme Court actions, the rights to control that property reverted back to the underlying property owners. And there were 27 of those property owners along this 3-mile route. And they said, and they got together and took a class action suit to the court and said, the Surface Transportation Board, which is the federal agency that gave that trail easement to UTA, said you had no right to do that.
Jim,
And
just a heads up, you've got 1 more minute.
Okay.
Thanks.
You have no right to do that. And so they went to court, took the Surface Transportation Board to court, and won. Now what happened was the easement stayed in place. However, that 3 miles of easement cost the federal government $24.5 million. And we were just the lucky beneficiaries of that federal largesse, if you will, in being able to build a trail on something that was very, very controversial for a very long time. Anyway, just to kind of give you an idea of some of the things that you may run into. And when Shane talked about having a lot of different tools to draw from, we drew from about every tool in the toolbox in order to get these trails built. Okay, and I'll stop here.
That was great. Thanks, Jim. All right, we will do some question and answers at the end. And in the meantime, if you've got questions, looks like Shane was able to chime in, so feel free to throw them into the chat. And with that, we will pass it over to Lora. Thanks.
Hello, my name is Lora, like you said, and I'm the director at Mountain Trails Foundation. We've been building, maintaining, and advocating for non-motorized trails on the Wasatch Back for about 30 years. I am just the 4th executive director and have been with Mountain Trails for a little over 10 years. I am going to probably just kind of go off the notes here I have here on my screen. You don't need to see them. I'm just going to tell some stories in the hopes that you guys can glean something interesting, or maybe it spurs some thought or a different way of thinking about what you're doing as you approach the recreation arena. So I'm not really talking about easements, but I'm going to talk about relationships that become partnerships, and partnerships kind of play into how trails can be built and maintained and expanded in a community. So if you're a member of a community, then, you know, especially if you're in a nonprofit like I am, you definitely have relationships in the community that you can capitalize on. So in order, you know, when you've got a good relationship with, say, a government staffer or a city or county council person, you kind of have to tune into like what their concerns might be around recreation or you know, trails specifically. So I'll just give you some examples of how Mountain Trails has dealt with, and some of our success stories, how we've dealt with our community partnerships. The first partnership we have, and probably one of the most long-standing, there's two. One would be with the Park City Municipal. We have a contract with them, and they pay Mountain Trails to do backcountry and side country trail maintenance. But knowing, you know, every council that comes up, it gets voted in, has kind of a different spin or a different focus. And so getting to know your council people or your staff members within the government is a great way to tune into what's important to them. Our government here is particularly concerned with trailhead parking and whether or not it's bleeding out onto side, neighborhood streets and blocking driveways and so on and so forth, because they hear from the residents. And so tuning into that, an example of the way we've kind of helped the Park City Municipal to deal with some of these problems is by working with Trail Forks and All Trails, which is a crowdsourcing mapping and wayfinding tool. And we've been in touch with them and said, hey, you know, we need to take a certain trailhead off of your map. It's a neighborhood trailhead, and we don't want the public necessarily, even though it is a public trailhead, we've got to be careful with how many people we're sending there, because, you know, something that's online has a way greater reach than just local word of mouth. So tuning into what the government was concerned about in that has helped us build a great relationship and keep a great relationship with them, such that, you know, there's reciprocity there. I will say that our other main partnership, and this one kind of is where we lean into easements, but that's sort of Shane's department. I'm not going to get into that, is with the resorts. So Deer Valley and Park City Municipal, or, I'm sorry, Park City Mountain Vale Resorts. We have great relationships with them. We have close to 400 miles of trails throughout Park City. I'd say probably 75% of that trail system is on private land within the resorts. So obviously, you know, keeping in the good graces of the resorts is a top priority for Mountain Trails and for the community. So we've put a lot of focus into not only maintaining those relationships, but considering how we're impacting the resort's land. It is private land. They own their land. It's not Forest Service land, which is leased, which is common to most ski resorts. But here up in the Wasatch Back, it's on private land, and we have to honor that. And there was a conversation a couple of years ago about whether or not we should place easements for the trails. And the conversation was to protect our trail system. It sounded like a great idea in the beginning when we first started talking about it. But the more we talked about it with our local resort leadership, the more we realized this might not be something that was advisable, because they're graciously letting us the public borrow their land. And by placing easements that were official, we were afraid that by running it up that flagpole to their legal department, we might actually be stepping on our own toes, or shooting ourselves in the foot, so to say. So we kind of backed out off that idea. And, you know, like I said, for around 30 years, we've been actively building a trail system that's now about 400 miles large. And it's worked great. It's sort of a handshake deal. We help them out. They help us out. They're part of the community. They're doing a great job allowing uses on their land. But we also, when Mountain Trails approaches them, we come with there's a responsibility to the private landowner, whether it's an HOA or a resort. You still have to honor that entity's concerns. And so, you know, just keeping in mind that these relationships that become partnerships it's really important, just like in any relationship, to understand what's important to the other parties. So yeah, so that's an area where we've had great success just by, again, just being good neighbors. Other nonprofits in the outdoor recreation, I know that there are a lot of youth programs, high school mountain bike teams. Those come in really handy when you need a little leverage with the community. So, or if you're writing a grant for, you know, say some recreation assets, getting letters of support and from these organizations can be super easy if you already have the relationships built. So I would just say that, you know, making sure that your easements don't have to be, you know, official in writing, but more the partnerships are kind of, at least on the Wasatch Back, have really been the way to go. I would also point to engaging, there's a lot of research now. I don't know if anybody's familiar with Headwaters. There's a great resource for verifying or backing up the value of trails in a community. And the Park City Chamber and Visitors Bureau has done a really great job of trying to address some of the local concerns around trail crowding, visitation, and they've got a sustainable tourism plan whereby they've given money to certain initiatives around town to sort of help with managing visitors and attracting the right kind of visitors. So if you are in a community that has a chamber bureau, highly recommend getting involved with them. They are kind of an endless source of great information and connection to the business community, or in Park City's case, into the tourism, you know, the arena of tourism. So I don't know, let's see, I'm looking at my landowner is caring about, okay, sorry guys. Yeah, Sky Ridge Development, that's a great story too. So Sky Ridge Development is a mountain community development. It's a, you know, development just like is a home. And they exist under MIDA, and MIDA dictates trails as part of the master plan. So, and that kind of came out, I will credit Don Taylor for that in Wasatch County. He's the trails coordinator down there. And I believe he also is on Mountainlands Association of Governments, but they've made a really great effort in Wasatch County to require new developments to include trails. And that didn't just kind of come out of thin air. That came through hard work and perseverance on the part of people who actually, you know, had great relationships and cared to see trails put into place. So, you know, again, that kind of goes back to the relationships that DT has with, Don Taylor has with, had with the county and the cities and the developers themselves. And, you know, the way he's had kind of a big picture view for Wasatch County. Park City does have some, it's not quite as robust, but we do have some requirements that if you come into Park City and you want to develop a housing development, for example, you've got to, trails have got to be part of your master plan. So, you know, people who have the vision for outdoor recreation can also see how valuable it is to the economy. There's some great data, again, if you go to Headwaters, it'll show you tons of data on how valuable trails can be in a community. I think I might be bumping up against my time. I hope that was useful. And if you have questions or want specifics, feel free to give me a call.
Lora, I think that was fantastic. Thank you so much. And we've got some good questions that folks have in the chat. So we'll go through a couple of resources, and then I'll do a quick poll for everyone, and then we'll open it up to more Q&A. And if we don't answer your questions now, we will follow up and try to share more resources with you, and kind of as a community in Utah, build our knowledge together about these things. So first of all, I want to give a shout out to the Utah chapter of the American Planning Association. I see a lot of familiar planner names here, which is exciting. That's my background, so I have a little bit of bias, but we are thankful for their, they were offering CE credits for participating, so we appreciate that. We wanted to, all the speakers today, we kind of put our heads together and we're thinking, what kind of resources should people know about? And so we wanted to highlight the Utah APA listserv, and it's just a good community of asking questions and growing that body of knowledge throughout the state. And chances are, if you have a question or you want a development standard that, you know, requires a trail or encourages, incentivizes trail through the property, there's probably a precedent out there, and people can help each other out. So APA Utah is one. We also wanted to let folks know about the Utah Office of the Ombudsman, which can help citizens in government understand property rights, resolve disputes, and advocates fairness and balance when private rights conflict with public needs. And they can also host trainings in your community. They can come out and help mediate tense situations with property owners, and they're a great resource. They've got wonderful staff. The other resource is the Land Use Academy of Utah, which also provides a lot of training opportunities, and they can come out to you. Their website is great, so I recommend perusing it and pulling the kind of guidance and resources that you're looking for. I think the specialty here is really in that land use application. So that's, you know, really beneficial for a local elected officials or just community representatives or planners. So last but not least, well, this is second to last, I guess. Building relationships is huge. Lora mentioned that. Jim, you know, when we were talking prior to hosting this webinar, he said that one of the biggest successes in getting the individual approval from all of those, I think it was 23 property owners, was, you know, listening, figuring out what their concerns are, and then working with them to make sure that those were addressed and helping, you know, not have one roadblock in a huge segment of trail. So again, yeah, just build relationships with your local elected officials. They can help you champion projects or find funding. Land managers are a huge part of the equation in Utah. We have so much federally managed land, so that's important to get to know your land managers and try to build that trust and rapport with them. And then just your community leaders. So again, we kind of talked about the values of property owners. So that's just something to keep in mind. And then finally, before we jump into our little poll and questions, we wanted to give a big plug for the Utah Trails Forum. It is a community of advocates, volunteers, land managers, industry professionals, trail users, and community leaders, the whole array. We get together annually and just share knowledge. We do field workshops. It's a fun 2 days or day and a half. And it's a great opportunity. So we'll be in Richfield this year. We're really excited. That's May 10th and 11th. So mark your calendars and we hope to see you there. If you're a student, I don't know if we have students here, you can reach out and we'll give you a discount code. So with that, I'm going to pause here and pull up my Mentimeter. Okay, so you should see something come through in the chat as well as on your screen. You can do this from your phone, or you can pull up the URL in a browser. That's menti.com, and then you enter that code. So if folks, I know it might take a second for folks to get on live and situated, but if you want to do a thumbs up or chime into the chat that you are there and with us. And can you all see the Menti? Okay, we're getting some thumbs up. All right, looks like we've got 6 people on, 17. We just got a full subscription to using this, so I've been using it in all my presentations lately. It's a fun tool. Okay, we'll give it one more second while folks get situated. Okay, I'll go to the next slide and you'll still be able to see the code and everything on the top of the screen. Okay, so this is just out of interest. Who are you? Who's listening in on this webinar? I know we've got a lot of planners, but do we have nonprofits? Do we have, what kind of government representatives do we have here? Just curious. So lots of cities and counties, lots of nonprofits. Awesome. Give it another minute. No one from the Conservation Corps world. Interesting. Lots of government. Awesome. Oh, we do have a federal government person here. Awesome. It's kind of fun to see who's in the audience. All right, I will go to the next slide. Sorry if you didn't get to chime in. We're just a little bit tight on time, so I want to make sure we get to everything here. So you know, if you're working for as a planner for a community, or you're an elected official, I'm just really curious how many of your communities have adopted trail standards or trail development incentives? Okay, we're seeing a lot of green lights. Awesome. Okay, that's helpful to see. We'll go to the next one. So this is a ranking question, so you can go in and drag what kind of resource might benefit your community the most or the least. We're interested in seeing how we can support you from the division level. You know, if there's examples or precedents or just other resources that we can provide to help point you in the right direction. Curious to see what folks are looking for. All right. Sorry for the, if there was a little bit of confusion getting into the Menti. It seems like a lot of you have figured it out. So interesting. It looks like a how-to guidance document seems to be ranking as the #1 thing here. And I know we're nearing the top of the hour, so I don't know if I don't think we'll be able to answer everyone's questions today. But if you still submit a question, that will help us be able to build out resource guides, even if we're not able to address it here in the next couple of minutes. So with that, I know a lot of you have been putting your questions in the chat, which is great. We're saving those as well. But if you want to submit them here, that is also an option. And you know, feel free, any of our speakers, if you want to come off of mute, maybe address any of the comments in the chat, or have any final thoughts there, you're welcome to do so.
I just put some responses in the chat. So I think I got everything that was addressed to me.
I think same here.
Awesome. Okay. Well, here is I just shared a Google Doc in our chat that has a link to our PowerPoint and all of the different URLs that were referenced throughout today, which is like the Bridalveil Falls, conservation easement, headwaters economics, just put a link in there, like Lora mentioned, and hopefully some other good resources. And we'll add to it again as we evaluate all of your good comments and questions in the chat moving forward. So I will, I know we're at the top of the hour. I'll still hang out for a few minutes just to let folks add more questions here, give you a couple minutes to think. But if you have to head out, thank you so much for your time today. It was great to have you. Thank you for all of our speakers for making the time and spending the lunch hour with us. So I really appreciate it. You all have a lot of wisdom, a lot of knowledge to share, and it only just helps our state be with better recreation access. We love to see it. So thank you all. And for folks that are looking for the CE credits, I will add that link to our resource, to that resource Google Doc that I sent out. I did not do that. So yeah, that's a good question. Thanks, Paul, if you're still on the call, for asking that.
I'm going to jump off, Carly.
Thanks, Shane. Appreciate your time.
You bet. See you. Thanks.
Just a quick thank you, Carly, for putting this together. This was lots of fun.
Oh, thanks, Jim. Yeah, lots of fun for me too. I love hearing about the success stories and seeing our community of movers and shakers join us. So thank you.
Hi, Jim. John Knobloch here, and so I'd want to touch base a little more on. We can do this offline.